and have fun. Enjoy it.
Okay.
Speak loud enough for two things. Speak loud enough because there seems like there are some students up top. It gets difficult to for them to hear. At least it did this morning. This microphone's not the best microphone in the world. Speak loudly. They're your audience. Make sure that they can hear. Speak loudly enough to keep them away. He's our court clerk.
All rise. The Honorable Court of Appeals of the 7th District of Texas is now.
Please be seated. We welcome you to the settings of the 7th Court of Appeals at the Law School in Lubbock, Texas, Texas Tech University School of Law. Thank you for agreeing to come down. Not that you had much choice, but thank you anyway. We do appreciate the opportunity to come here, and we do appreciate having live argument here to give the students opportunity to see attorneys in action. And if they care to do something like this down the road, they can see what they're going to be going through. A learning experience. To my right is Justice Parker. Came on the bench 4 years ago, 5 years ago, after being on the County Court of Law bench here in Lubbock. And on my left is our newest addition, Justice Doss, Larry Doss. He was in private practice until about 2 years ago. And we're lucky to have him appointed to the court, and then he won election. So he's got some good election stories to tell you if you ever have time. With that, we'll go on and call the docket. And we have two cases for this afternoon, but we will have a panel change, so we'll take a brief recess in between them. The first case we have for this afternoon is 07-21-00259-CV, and something I forgot to do, segue, this morning I'm going to do now. To my far right, the person that likes me so much, we have the same haircut, is B.A.B Ramirez. He's our court clerk, but he's also our general counsel. Thank you. Again, 07-21-00259-CV, in re B.A.B. Ms. Smith for the relators, are you ready? Thank you. And Ms. Mulino for, tell me if I didn't pronounce that right. Molinax, for the real party interest. You ready? Ready. And you both know that you have 20 minutes for your argument, and the relator has 5 minutes rebuttal. Okay, thank you. Whenever you're ready, Ms. Smith.
Your Honors, may it please the court, my name is Sally Smith, and I'm here on behalf of the relator, Brett Brewer.
Okay, I'm going to ask you to kind of you can either hold that microphone or you can put it
Closer?
in front of you, but we're going to need that microphone unless you're opera singer and you can project.
Is that loud enough? Is that better?
Yeah.
Much better. Awesome. Okay.
Good? Okay.
I'd like to introduce
They
you
gave
to...
you the thumbs up, so.
Okay. Introduce you to my client, Brett Brewer, and his daughter. In the spirit of the rules, I'd like to refer to her as Allison, her middle name. And we're here today in a mandamus setting that always often involves absolutes, either absolutely no evidence or absolutely conclusive evidence, or an absolute clear abuse of discretion. And in this case, I think there are several absolutes. The death of Krista Graves, Lori and Wendell Rauman's daughter, was an absolute tragedy. And the decisions that they made after her death to pursue a custody case absolutely placed upon them the entire burden of proof to demonstrate they had standing and to overcome a fit parent presumption. I believe that there was absolutely no way that Judge Estevez was going to remove Allison from the Raumans' care on an immediate basis. I think that becomes clear. I believe that Brett Brewer was absolutely entitled to a fit parent presumption. And when that did not play out in the trial court, that there was an abuse of discretion. There were two hurdles that the Raumans had to overcome in order to prevail in this case. The first one being to establish that they had standing, and the second, to be able to offer sufficient evidence to overcome the presumption that Brett was a fit parent. And to the extent of covering the standing issue first, the court is certainly well aware that as a threshold issue, standing implicates the subject matter jurisdiction of the trial court, and therefore a party must establish that they have the right to maintain their lawsuit. In the U.S. Supreme Court case of Troxell versus Granville in 2000, the Supreme Court said that implicating the power of the trial court to make decisions and enforce its orders between a parent and a non-parent, to the extent that they're going against a parent's choice, a parent's discretion, that implicates fundamental liberty interest for that parent at a constitutional level. And in the jurisdictional scheme of things, we have a statutory scheme that is relatively specific in the Texas Family Code. And if that scheme is violated, then it necessarily invokes the violation of constitutional rights. In the case of N. Ray Pensum, which is out of the San Antonio court, they indicated that standing statutes should be interpreted with those constitutional presumptions and implications in mind. So in this case, the Raumans initially claimed standing under two separate statutes, 102-003A9 of the Family Code, which we call the Actual Care, Custody, and Control Statute, and then 102-004A, which is the Significant Impairment Statute, establishing that they have a right as grandparents to seek custody because the appointment of a parent would significantly impair the child's physical health or emotional development. On the morning of the hearing, the Raumans abandoned their significant impairment standing ground when they amended their pleadings, but I do want to touch on it nevertheless because a great deal of time and attention was focused on it before the trial court in the standing phase of the case. And it was, according to the record, with the only witness that testified, which was Lori Rauman, the grandmother, that there was a concern if Allison went into Brett's care. Not that there was a current existing impairment that could be identified in Brett's care, but just the worry and concern that so shortly after her mother's passing, that she would be removed from a situation that she was most familiar with. She would be taken away from her brother, from her school, that she had some learning disabilities. They were concerned about how that would impact her. And all of those things, to me, speak to not a focus on Brett as having any concerns that his environment could significantly impair this child, but that the removal from them and her present circumstances was just simply not in her best interest. There was really, if significant impairment could be said to have been tried by consent that morning, then I absolutely think there was not sufficient proof to establish that there was any impairment that the child was facing in Brett's care. But the second ground for standing under 102.03A9 required the Rahmans to establish that Allison had been in their care for 6 months as her primary residence, and that they had provided actual care and control. And the Texas Supreme Court, in the case of In re HS, has given us a considerable amount of guidance as to what that requires. It establishes that the 6-month period does not necessarily have to be continuous, but it has to be the child's primary residence, and then the grandparents in this case, had to exercise guidance and governance and control over her on a day-to-day basis in a parent-like capacity.
Well, in this case where the father was not permitted to testify,
Yes, ma'am.
can we consider his affidavit that was attached to his pleading?
I think certainly the law supports the notion that a trial court may certainly take judicial notice of the contents of its file. It may do so without anyone asking it to do so. And I think there is also case law that establishes that you, as an appellate body, may assume that the trial court took judicial notice of its file. Whether Judge Estevez did that or not, I do believe that those affidavits...
Taking judicial notice of the contents of the file, or taking judicial notice of the file for purposes of acknowledging the truth of what's stated in things in the file?
I actually think that it should be the former, but I will tell you that there is a recent case, and I can give you the citation for that. It's in the interest of MLP, and it is a 2022 case, Tex App Lexus 2022 at 250.
What was it? In re what?
MLP, the initials MLP. It's 2022 Tex App Lexus 251. And that's a case that came out of the Corpus Christi court in January of this year, where there was a psychological report, an evaluation or custody report that was in the court's file. It was never admitted into evidence. The Court of Appeals affirmed a decision wherein it assumed that the trial court took judicial notice of that custody evaluation as supporting the decision that the trial court made. And so in that instance, it was certainly used as substantive evidence to support the issues. I think I sort of find that rare, but it's an interesting case that nevertheless, I think addresses your question. And certainly in the affidavits that Brett Brewer filed, he did dispute a lot of the claims that were made by the Rahmans in terms of the extent of their care, the length of time of their care. And I think if you look at the record of the testimony that was given, Lori Rahman claimed that the child had lived with them since birth. That was her initial testimony. But then under cross-examination, she admitted that the child had lived with her mom in an apartment, but just not full-time. Well, that means it was part-time. And then Lori Rahman admitted that, or claimed that the child had been with them since September. Interestingly enough, the September date is exactly 6 months from the March date when their case was filed. It is the 6-month period that has to be judged. And Ms. Rahman testified that the child had come to live with them in September because of a CPS case involvement. But the CPS caseworker testified that the case did not begin until December, which actually cuts 3 months off of that 6-month time
Do we have a
period
dispute whether or
and
not
negates.
it's September, December?
Well, and actually, the December testimony came in the temporary orders phase, not in the standing phase, so I don't think that Judge Estevez necessarily heard that in making her standing decision.
Well, can
I'm
a
curious
court-
about that.
Yeah, can a court consider evidence presented on the merits to determine standing?
Well, there are certain situations, I know in 2019, this court actually decided the DKP case, which was an issue where a grandmother sought to maintain standing to seek conservatorship of her grandchildren. And it was very contested, very disputed. The mother challenged not only the 6-month period, but she also challenged the actual care, custody, and control component. And in that case, this court found that if the standing facts create a material fact, that a plea to the jurisdiction should not be dismissed, particularly when those facts are also relevant to the merits. And in this case, the evidence of actual care and control went to the merits of whether or not this grandmother should actually eventually have custody. And so this court found that there was, almost under a summary judgment standard, a sufficient material fact that had been established so that the plea to the jurisdiction should not have been denied. So in response to your question, I think surely I could envision a situation where a court heard the standing issue, found it as a preliminary matter, went on to listen to some other evidence, and potentially could have changed its mind and heard conflicting evidence or thought that maybe it should rethink the standing decision. But you don't get to the temporary orders hearing phase unless standing is established. And Judge Estevez did that in a somewhat of a rushed manner. There were comments of speeding along. We have 5 more minutes. I need to make this standing decision if we're going to have a temporary orders hearing. And eventually asking trial counsel in the April hearing to move on, and then she ruled and granted standing. So
I may be misinterpreting Justice Parker's questions, but I heard her ask whether or not you can use evidence in one hearing or evidence as evidence in another hearing. Is that the tenor of your question?
Yeah, but what happened here was after the initial determination as to whether there was standing or not, that was tried first, then it was determined there was standing, and then it moved right into, there wasn't a break, wasn't multiple hearings, it's really just, it's all at the same time.
it moved in immediately into the temporary orders phase of the hearing, and
Was there a request in the second hearing of the judge to consider the evidence in the first hearing for purposes of the second hearing?
there really wasn't a break in the hearing. It was simply, call your witness now in the temporary orders phase. It was just, I've ruled, we're having standing, now call your witness in the temporary
Do
orders.
you think our review of the appellate record is only limited to the first portion, the standing portion, or do you think we can look at the whole thing?
I think that you can look at the whole thing, and I think that it makes Mr. Brewer's case actually stronger if you look at the whole thing. I think under a de novo review, you're being asked to infer and imply a lot of things and speculate about a lot of things, and that leads me to the second component of the standing argument, which is the care, custody, and control.
Let me ask you this. If you take out Mr. Brewer's testimony, whatever, from that hearing, would there be evidence in the record to support what the trial court did?
If the pleadings alone were, and the affidavits alone were considered, would there be evidence sufficient?
Or the grandmother's testimony?
Mr. Brewer did not testify. Ms. Rallman, the grandmother, was the only one that testified.
Exactly. Okay, but you take out apparently his affidavits, et cetera, and you just look at the grandmother's testimony. Is there enough there to support what the trial judge did?
I don't believe so, and I think that is substantially evident in the second component of actual care and control, The Supreme Court in the case of In re HS tells us that it has to be the child's primary residence for the 6-month period, and there has to be evidence that supports the day-to-day parenting role of the grandparent, in this case, with the child. And that second part of it, I think the evidence is absolutely absent. The only evidence that was submitted were three items that Ms. Rahman testified to. She indicated that she took Allison and her brother to school and to church. She put Allison to bed on Sunday evenings, and they had enrolled the child in play therapy after her mother's death a month before. That was it.
At this time, were the child allegedly living with the grandmother?
From December, according to the CPS worker, she was primarily in the
Unless you
Rahmans.
believe the grandmother who said September or 3 months earlier.
Correct. But the grandmother also admitted that the mom had her own apartment and that Allison stayed with her in that apartment, just not full-time, almost as if they're sharing the parenting
She stayed
duties.
with her on the weekends?
That was the testimony once the CPS case took over in December, that she stayed with her mom on weekends and would come back on Saturday evenings.
So evidence is kind of contradictory. You could say she did, there was some evidence to indicate that maybe she was there from September, not just December. She lived there through the week, just went to the mother on the weekends. But even though the grandmother said, I put her to bed, took her to school, whatever, if you're living with the grandmother, can you infer logically that the grandmother was feeding them, washing their clothes, clothing them, providing guidance to them? Or is that something we can't infer?
I think
By the fact that they're living with the grandmother.
I think that you have to make a lot of inferences, and I think that when we are dealing with the issues of constitutional proportions in protecting a parent's fundamental rights to their child, that it can't be that simple, Your Honor. It just, there has to be a level of evidence that really establishes that this is the role that they are fulfilling for the entire requisite period of time. And I think that is completely absent here. I think they're
What about conflicting evidence from grandmother herself? She said on the one hand, she's been with me since birth. She said on the other hand, well, she's been with me 6 months. As a reviewing court, what weight, if any, do we give when we have conflicting evidence from the one witness who took the stand?
I think that it calls into question whether or not the evidence, the weight of the evidence is sufficient to carry this very extensive burden. And I think it's also manifested in the pleadings themselves that didn't really talk about primary residence. They talk about continuous care. It's not the standard under the statute. It's not the standard that the Supreme Court in HS has established.
Well, aren't they required to plead the statutory grounds for standing?
And they did.
Well, initially.
Initially, they said since birth. The child has lived with us since birth. The amended pleading on the day of the hearing said that the child had been with them since September 1st.
Still within 6 months.
That's the 6-month mark from the March filing.
Historically, in a setting where there has been evidence and the trial judge is a fact finder, and even I guess in a jury, we defer to the fact finder's ability to resolve disputes in the evidence, conflicts, even if it's one witness and that witness has given contradictory testimony. Do we do the same here?
I think that's true when there are sufficient disputed facts. In this case, we contend that they are simply not there. That mandamus, and I think there's a second path to this.
If there are sufficient disputed facts, but they're contradictory, can we do a mandamus? Isn't there a rule in mandamus that if the decision is based on an evidentiary record, that mandamus is inappropriate?
It does say that, but again, I think that our position is there just isn't. When you break down this record, it just is not there. And while it may be disputed as to primary residence for a 6-month period, there is literally no evidence without speculation and inference about actual care and control. And the mandamus response filed by the real parties in interest actually admit that. They actually admit that the court never allowed them to put on specific evidence of actual care and control. There was a question that came to Ms. Rauman, who took the child to the doctor in the last 5 years. There was an objection, it was sustained, and she passed the witness, and the questioning never resumed. And so they have admitted that it is up to you,
How old
the
is the
appellate
child?
body. I'm sorry?
How old is the child?
She's 6.
Six.
She's
Six-year-old
6.
child take care of herself?
Pardon me?
6-year-old child can take care of herself? Is that reasonable to assume?
Probably not. Probably
Can we
not.
factor that into the equation when the 6-year-old child is allegedly living with the grandmother and the mother's not around?
I think, Your Honor, I think that you can factor that in, but again, I would say that Ms. Rauman admitted that they took custody of her when the CPS case began. She claimed it was September. The worker testified it was December. It takes 3 months out of the equation and completely negates the very specific standing requirement under 102.003A9. But I think I would also say that the factual issue is not the only path to mandamus here, because clearly the court is mindful of the fact.
Counsel, your time has expired.
Oh,
I'm sorry.
goodness,
Our
I didn't even
questions
get to
took you
issue
from there.
2. I'll do that in the rebuttal.
Okay.
Thank you.
Thank you. It keeps ticking on the device I'm looking at, and I've got to remember to look over there.
May it please the court? Y'all can hear me. My name is Erin Mullenax. I represent the real parties in interest, Lori and Wendell Rauman. As Ms. Smith stated,
Real quick, can you guys hear? Thank you.
As Ms. Smith stated, there were some issues brought up as to whether the Raumans have standing in this case. Our position is, while the affidavit of Ms. Rauman at the very beginning stated that she had the child since birth, and then changed it to September 1st of 2020, that still satisfies the requisite time period for the standing issue. Even though that was changed, she did testify in that hearing on April 8th of 2021 that the child had resided with her since birth. At points, Krista, the mother, had resided there, but at no point in time did the child, Allison, specifically live with Krista for any significant period of time. She had her, I believe the statement was she lived with her mother on the weekends. And
If I
so,
remember the record, the affidavit was included in grandmother's initial petition, and then when the amended petition was filed, it made reference to an affidavit, but there was no affidavit in the pleadings?
I believe it's correct that the affidavit was not contained in the pleadings. As far as standing under section 102.003A9, I don't believe that there's required to be an affidavit, only if there's a significant impairment to the child's physical health or emotional development. So as long as they alleged in their petition that there was standing under section 102.003A9, then if they could provide that evidence at a hearing, then that would be sufficient.
I understand from opposing counsel just a minute ago, maybe there's a disputed fact over the length of time, whether it was 6 months, whether it was since the child's birth, whatever. What evidence is there in the record of that your client provided for the child's daily physical and psychological needs?
With regard to Ms. Rauman's testimony, she testified that the child lived with them during the week and would see mother on the weekends, that she would come home on Saturday nights, they would get her ready for bed, take her to church, get her ready for school, and take her to school. I believe that's the only evidence that's established in the record. However, as stated, she's 6 years old, and these things that they're doing for her, she can't do for herself. And so someone has to take care of her while she's residing primarily at the Raumans' residence during the week.
But we don't know from the record unless we're just speculating whether it was your client or somebody else who was doing that, right?
In fact, I believe Maria Chacon, the second CPS worker that testified, first off, she said that when CPS became involved in December 2020, that the child was living with the Raumans at the time that CPS visited the home, and that I believe it was her, that their home was her home. And so mom would come over and help take care of the child, but just because the mom comes and helps take care of the child does not mean that the Raumans don't have standing, because the parents don't have to completely abdicate their authority and possession and access to the child and their parental responsibilities.
Is the same thing true on evidence of your client exercising guidance, governance, and direction similar to that exercised by a ordinary parent? Are you asking us to draw the same inferences based on that testimony?
Yes, Your Honor, based on the testimony that the child was primarily living at the Rowlands residence, because I don't believe, absent the testimony that Krista had come over and helped out with the child, I don't believe that there's sufficient evidence to show that she was there 100% of the time and taking care of the child's needs 100% of the time. So I believe that it would be fair to infer that the Rowlands were taking care of the child's needs because she was living at their residence full-time.
Is there any testimony in the record, maybe related to another topic, about the needs of the children and how healthy they were and at the time of the hearings, et cetera?
I don't know about the physical health. I know that there was testimony that Allison had some learning disabilities. She was nonverbal. She was having some issues, having outcry or getting very upset because people didn't understand her, and they were taking care of those needs.
But that would go to the merits of the case and not standing,
Correct.
wouldn't it? Yeah.
Okay,
Right.
go to standing as well? If she has a need and it's being taken care of, and when you said they were taking, who's the they?
They being the Rowlands,
Okay.
both of the Rowlands.
Yeah, well, so I add that she had a need, it was being taken care of, and it was the Rahmans that were taking care of it.
Yes.
Could that be, even though it goes to the merits, could that be attributed to standing too?
I believe, as Ms. Smith stated earlier, I think that the record could be taken as a whole since it was the same hearing, and that those things could be considered in the standing issue as well. With regard to the CPS worker, like I said, she testified that Allison was very bonded to the Rowlands, and that during the transition she would just cry because she wanted to be with her grandparents because that was her home. And so I believe that's significant to show that her home is the Rowlands' home and that they're the ones that care for her primarily.
The test isn't whether or not that was her home. The test is care, custody, control, et cetera.
Correct.
So, I guess,
And so the test in NRA HS is whether they're sharing a principal residence with the child, which I believe has been established through the testimony, that she was living there during the week and that she would see her mother on the weekends. Providing for the child's daily physical and psychological needs. Again, as you stated, as you asked, I believe that they were taking care of her daily physical and psychological needs by taking care of her needs, going to school, helping her learn to speak. She was in kindergarten, I think, for the second time because she had some psychological disabilities that were being taken care of by the Rowlands. I believe that can be considered. And exercising guidance, governance, and direction similar to that typically exercised on a day-to-day basis by parents with their children. And I believe that the testimony of them caring for her, getting her bathed to bed, taking her to church, taking her to school, all of those things, though not significant information, I think that those things go toward showing that they're taking care of the guidance, governance, and direction similar to that that a parent would do. And so the other issue, if we prove standing, whether it's under the significant impairment 102.004 or the care, custody, and control, we still have to prove that the parent is not a fit parent.
Well, are you conceding that you did not present significant impairment?
I believe there was testimony of significant impairment. My understanding is that if there is a suggestion of significant impairment, there has to be an affidavit, or there's not even a hearing scheduled. After, I believe it was the Relator's attorney filed a motion to dismiss for lack of standing, stating some specific things that weren't in the petition was amended by the current attorney at that time, and the significant impairment condition was taken out of that, and there was no affidavit attached. So I would have to concede the fact that there was not an allegation of significant impairment after that second, the amended petition.
So for standing purposes, then the only thing we're looking at is 102.003A9?
Yes, sir, I believe so. And so even if they're standing under either of those, there still has to be there's the fit parent presumption that we have to prove that the parent is not a fit parent. During the testimony, there was testimony from CPS workers that CPS had become involved several times. During those times, they had tried to contact CPS, being they had tried to contact the father and sometimes it would go several months before he would contact them back, or one time, I think it was July, that is whenever, prior to the family-based caseworker taking over the case, there was an affidavit or an email attached to the first petition that was from Mr. Brewer stating on, I think, June 24th of 2019, he was authorizing the child to remain in the residence of the Raumans and that she currently lives with them and it would be in her best interest to continue. So clearly she had lived there prior to September 1st of 2020, though it's at issue how long she had actually lived there.
With regard to fit parent, is there a definition of fit parent?
I don't really remember seeing an actual definition of a fit parent other than someone that acts in their child's best interest.
Say that again.
I don't actually remember seeing a definition of fit parent other than someone that acts in their child's best interest.
Well, the statute talks about circumstances that would significantly impair the child's physical health and emotional development. I mean, do you think it's beyond simply, do we think this is a good parent or not? Or do you think the evidence has to be specific to physical health and emotional development and the effect that that environment would have?
I think the answer would be both, that there has to be possibly showing of significant impairment to physical or emotional development, and or that there would be additional evidence to just show that the parent's not acting in the child's best interest. So basically.
So how would his decision in 2019 impact, was that an incorrect decision for him to have decided as the parent that the child should remain temporarily with the grandparents?
I don't think it's just that decision. If it was just that decision alone, I think that there wouldn't be an issue. There were several other decisions. CPS became involved. He either would not return their calls for months.
But the CPS was involved, weren't they, with the mother, and there was referrals made on conduct on the grandparents?
Correct, and those were ruled out, and that information is actually included in Mr. Brewer's evidence on some of his exhibits attached to his pleadings.
Okay, so, but there was no CPS involvement on his part?
Correct, but during those CPS cases, the department would try to contact him, and he would either not answer them, not contact them back, or leave the child where the child was. At one point.
So what we have is his agreement to allow the grandparents to care for the child and unavailability. Is that the sum and substance of the evidence of unfit parent?
No, there's additional. So in 2019, I believe it was, there was a CPS case where the Rylemans were taking care of the child, and I believe that was at the beginning of the case when he said that the Rylemans should continue to have the child. He actually moved to Amarillo to live with mom, and he brought alcohol into the residence knowing that she could relapse. And then when he was told that he could not do so, he got upset with CPS, called him and said he was leaving and didn't come back. And he didn't file a petition to modify. He didn't attempt to take control of the child. He didn't do anything with regard to the child. He left her in that situation. Same thing with December 2020. He
left her with a mother who was trying to dry out.
Yes, but that
Not a mother who was drunk.
Well, the mother had relapsed previously and was having issues with alcohol, so she was only having supervised visits with the child, as far as the record states, by the CPS worker. And so.
But it was the mother that said, "I don't want you to bring alcohol in here."
No, it was the CPS worker.
CPS, okay.
Yes, that said, you can't bring alcohol in. We expect you to help her. And then he decided he didn't want to abide by those things, so he left and went back to Houston. Didn't even attempt to take his child, didn't attempt to modify the order to take his child to get further orders. In December of 2020, he was contacted, and he didn't get back with the department until January. At that time, he made no attempt to contact an attorney or do anything to get custody of this child. The mother died from complications of alcoholism, and so that was her problem. Beginning of March, on March 1st of 2021, CPS contacted the father of the child and stated, you should seek an attorney to get custody of your child. And he said, I've been worried about her drinking for years, and he still did nothing. She died, I think, 9 to 10 days later, but during that period of time after he'd been notified by CPS, at that time, he still did nothing. So my argument is that a fit parent would have done something in the at least 2 years prior to to the mother's death to take custody of the child, or at least to seek a modification to do something with regard to the child, instead of just not contacting the department and leaving the child with the grandparents to take care of so he didn't have to do it.
What about your client? Did your client take steps at that point to terminate mother's rights or anything?
My clients did not take steps. They did have, I believe, a safety plan giving them the possession of the child, but they're not really obligated. I realize that it would be a good thing for them to do, but they're not obligated to file a motion to modify because they weren't conservators at that time anyway. Father was a conservator at the time, and if he had had significant issues with mom's drinking for years, then he should have done something.
Your position is he was obligated to seek to modify possession and access at that point based on mom's conduct?
Yes.
And that his failure to not modify were the circumstances that placed the child in safety and physical health and emotional development at risk?
Yes, his decision not to modify and his decision to continue to leave the child, where in his affidavit, he says mom had the child was currently residing with mother up until December of 2020. So if he really thought that and he had concerns of her drinking for years, then he should have done something to alleviate that issue.
Was there any testimony put on about why dad made the decision to not modify at that point?
There was no testimony by Mr. Brewer at all. So I don't believe there was any testimony with regard to that issue other than
Does that
him.
not bring up some constitutional, excuse me, issues?
It could bring up some constitutional issues. I don't think that the court abused its discretion in finding standing or making the order that it made. I think at the very most that it did was it probably should have allowed all of the parties to testify and not hurried them along. And so I do believe that's an issue.
Yeah, it seems to me like we're, at least from your position on your second argument, you're going after dad for not doing things, but dad never had an opportunity to explain why he did or didn't do it because the judge didn't give him an opportunity to testify.
I understand that, but he also wrote an affidavit with a lot of issues in it. And so if he had some issue, or if he had an opportunity to provide testimony in his affidavit as to why he didn't do things, he could have done so because he explained everything else.
Do you have any problem with this court considering that affidavit?
No,
And the affidavit doesn't have any explanation of why he didn't do any of that?
not that I recall.
We've seen your name a lot in our court. You handle a lot of termination appeals.
Yes, sir.
Those termination appeals, as you know, terminations can be grounded on placing endangerment, leaving a child or an endangering situation that it's not beneficial to the child, the welfare of the child, et cetera. Would what you just described, leaving a child with an alcoholic parent who relapses, not having any communication with that child, real quick, was there any evidence that he supported the child?
That he supported the child? I don't believe there's any evidence to his child support or anything like
So
that.
you throw in there a lack of support for the child.
Well, wasn't there evidence?
Would that be basis for termination?
Under the endangerment?
Yes.
I think it possibly could be because he would have an obligation to do something to alleviate the issues that the child was in. So he could have left the child with the other parent and endangered the child by leaving that child with the other parent.
Assuming arguendo, there's authority out there that supports that. Would basis for termination be enough to show unfit parent?
There would have to be a best interest also.
Of course.
Right.
That's not in the calculation.
There are grounds, though, under the termination provisions for knowingly placing a child in circumstances or environment that,
Or allowing them to remain.
or allowing them to remain.
And clear and convincing evidence,
True,
too,
too.
would be the burden of proof. But wasn't there statements in his affidavit indicating where he resided, which was over, I want to say it was over 9 hours away, but I don't know that for a fact, but a great deal of distance, that he did exercise. He was a joint managing conservator. He exercised periods of possession. He had a recent summer possession with the child in 2020, which would have been, I want to say it ended either in July or August of that year, and had time with the child at Christmas, which apparently was the time when the CPS case maybe was ongoing.
Yes, the CPS case began in December 2020, and I believe his visitation was from December 28th until January 3rd. And his summer visitation, I think, was sometime in July through August, the very 1st of August. So I would submit that I don't believe that it's necessary for a parent not to have visitation with the child to prove that the parent is unfit. A parent could have visitation with a child all day, but it doesn't mean that they're fit to raise that child on a regular basis.
They're fit to visit, but they're not fit to have the child live with them on a full-time basis.
Yes, to make the daily decisions of the child's physical health, emotional well-being, those kind of things. A parent with visitation, if they were going to modify the visitation because of the mother's alcoholism and her issues, they should have done that at the time.
Well, he wasn't just a visiting parent, he was a joint managing conservator.
I understand, but at the same time, he had given permission at least one time for the child to live with the grandparents.
Over 2 years ago.
Right. But I don't know when that ended because there was no testimony other than the email and then the information from Ms. Rauman's that started September 1st of 2020.
We may have glossed over this a while ago under A9, but I think you took the position that the child's primary residence was with the grandparents. And your reason for that was that's where the child's living 5 days a week. Is there any support for that the residence is determined by wherever the child lives more, or what other factors, if any, do we take into account when we're trying to make that decision?
Well, I think it goes back to the actual care, custody, and possession. So they actually had physical custody of the child at least 5 days a week. And I think it was 6 days a week because mom would see her from Friday to Saturday night. And then possession, obviously, care, custody, or control, I'm sorry. So they made decisions with mom. It doesn't matter. She doesn't have to abdicate her full authority to them, but they can make decisions. And I believe that that's to be considered whenever they're living with mom or with the grandparents 6 days a week. I would assume that they wouldn't just call mom every 5 seconds and say, hey, can we give her a bath? Hey, can we give her dinner? Those kind of things. And so it just seems like the necessary inference is because they had the child in their home for the majority of the time.
Counsel, your time has expired. Just Parker, I did step on one of your questions. I apologize for that. If you have any questions, please.
I don't think so.
I don't have any.
Thank you.
Thank you.
Speaking to the second issue of CJC, I think it's noteworthy.
Can you make sure you speak into the microphone?
CJC was not acknowledged, recognized, or addressed in the April hearing. It's as if it was not on anyone's radar. So the idea of a fit parent presumption was not something that any of the lawyers or I believe the trial judge considered. I think the case was decided on best interest, and I think that that is somewhat evidenced by Judge Estevez's comments when she ruled and said that this child has been through a lot. We're going to leave her where she is for right now. We're going to work towards the father being able to decide where she lives. But for right now, we're not going to do that drastically. He needs to bond with her. I think those are all best interest analysis. And I think it completely ignores that CJC says that Brett Brewer was entitled to a presumption that he was a fit parent. And it took evidence to overcome that presumption, which I think is completely absent. There is a case cited in the petition called NRA SD, initials SD. And that case talks about CJC. It came out in August. And it talks about the idea that when you had a father who had never been less than a joint managing conservator, who had never been granted supervised possession with a child, that purely evidence of best interest was not going to cut it and was not going to overcome that presumption. There was testimony regarding concerns that they had about Brett's past alcohol use. But those concerns there was never any evidence that he drank around the child, that he had been arrested or ticketed for anything, much less anything alcohol related, that he had driven with the child. There was no evidence
Is the lack of evidence, in your view, because the trial judge didn't give opportunity for that evidence?
Well, there is that, because the judge, after the two CPS caseworkers testified in the temporary orders phase, Lori Rahman was called back to the stand, and she was simply asked, what are your concerns? And she said, I'm concerned she'll be removed from us, that she would be removed from her brother and her school, and the judge said, that's enough, I'm deciding we're keeping the child where she is. That was it. It was over at that point.
If the court prematurely cut off the hearing, so to speak, and did not allow the attorneys to develop that aspect, and assuming that means you are entitled to your mandamus because there's no evidence, assuming arguendo, is the relief to say no jurisdiction, no standing, or is it to say there's not enough to support that decision, we send it back to the trial court to have a full hearing?
Well, I certainly think that there are two components to the mandamus and two different requested relief. We're first asking initially that you find no standing, therefore no jurisdiction, and dismiss the underlying suit. But in any event, if you determine that there was a fact issue created, whether it's as to the 6 months or whether it's as to the actual care and control, that if you believe that that fact issue was enough, that the evidence created enough, that you can't grant mandamus on that, then at the very least, we think that Mr. Brewer is entitled absolutely to orders instructing his immediate possession of this child, because there was no evidence as to his fitness at all as a parent. Simply expressions that if Ms. Rahman actually testified, in fact, that she had no concerns about Brett having Allison as long as he was around his family, and he lives with his parents.
Okay, I guess if we find what you said with regard to standing or standing, but you're saying there's no evidence of non-fit, and we grant mandamus on that, can that issue be relitigated in the trial court? Can they raise that again?
Well, according to Judge Estevez, her comment was, because this was raised when Brett's trial counsel determined that CJC was out there, she brought a motion to actually modify the temporary orders. They came back in September. It was actually on a continuance hearing, but the court asked some questions about what relief are you seeking. And she briefed CJC for the trial court, and the trial court, Judge Estevez, actually said, I know there is a fit parent presumption, but it is not an issue for temporary orders. That's an issue for final trial. And it's our position that Mr. Brewer's constitutional rights don't come and go during the process. They are constant. They exist at all times. And he was entitled, we believe, without evidence that he was unfit, that he was entitled to immediate possession of Allison in April. And if not then certainly in September. We're a year later now. He's continuing to exercise his visitation. And I actually think the trial court appointed him again as a temporary joint managing conservator and gave him independent rights in the temporary orders that exist. Those are significant. If he's an unfit parent, you would never do that. So CJC says there has to be a predicate finding that he's unfit. No such predicate finding exists in this case.
Obviously, you've made reference to your client's inability to testify at the hearing. We've talked about it today. We've talked about potential remedies for him not being allowed to testify. And I'm curious about this. Is a remand for a new hearing really what you want? Because it provides an opportunity for the other side to have its second bite at the apple and put on additional evidence.
No, we've not asked for a remand. It's just simply pointing out that he was, if there had been evidence that he needed to defend, that just did not happen.
If you have the opportunity to get an additional hearing, but you don't want an additional hearing, is there a constitutional concern that he didn't get to testify the first time?
I don't necessarily know that his inability to testify is a constitutional concern, because actually they carried the entire burden of proof. And if they didn't carry their burden, then there was absolutely no need for him to testify. And particularly with respect to the CJC issues, I do real quick want to point you to a new case that came out since the petitions were filed, and that's out of Fort Worth. It's called B.A.B, initials B.F. It's 2022 Lexus 8173, and it follows CJC, and it speaks to the idea that without evidence of current abuse, it was a father with past drug abuse issues, but it had to be evidence that showed how his concerns.
A little bit away from Justice Doss's question, and your time has expired.
Oh, okay.
So let me ask you, have judges have any other questions? You have questions?
Thank you. Appreciate the opportunity.
The case is submitted, and you are excused to go, and we will take a brief recess so we can change panels. And if the attorneys in the last case care to come forward, we would appreciate that.
All rise.